Okay, let's go ahead and get started. So first off, hi and welcome. This is CRS's presentation on the Just Housing Amendment to the Cook County Human Rights Ordinance. We're excited to have you here and hope that you will gain a lot of information and be able to use that and take it back to your churches. So again, thank you for being here. Before we begin, we will introduce ourselves. My name is Melissa Andrews. I am a member of Bethany UCC up in Ravenswood. I've been involved with Community Renewal Society for 3 years, I think, time goes fast, and the issue team for 2. Is it Ryan?
Hi, my name is Ryan Andrews. I'm also a member of Bethany United Church of Christ, and I've also been involved with Community Renewal Society for 3 years, and I've been on the issue team for 2.
And my name is Alan Lindrup. I'm a Unitarian Universalist. I'm transitioning between a couple of congregations, and I've been on this issue team about 2 years.
And I'm Jeff Jones. I'm a part of Urban Village Church, the South Loop branch, and I've been involved with CRF for about 2.5 years and the issue team for that time.
Good evening. My name is Will Boone. I'm a member of the Church of the Good Shepherd, UCC. I am also a member of the Board of Directors for the Community Renewal Society. And I've served on the board. This is my 4th year. And I've been a member of the issue development team for about 8 months.
Okay, so after going through the presentation tonight, you should have a better understanding of the context for the Just Housing Amendment, a working knowledge of what the amendment does, and the protections that it offers. Additionally, we want you to come away with the best practices and resources to share with others. Please remember, though, that we are not giving legal advice. If you have any questions, please put them in the chat, and we will have Will read them at the end, so they will be addressed this evening. Otherwise, if you can please go ahead and put yourselves on mute. Thanks. So let's start with scripture. Jeremiah 29:11 says, "For I know the plans I have for you, declares the Lord, plans for welfare and not for evil, to give you a future and a hope." Our faith teaches us that God wants us all to be provided for, to have a future. Stable housing is essential to one's welfare, and without access to stable housing, individuals lack the foundation. No pun intended about the foundations that we need here. If you'll please pray with me. Dear Lord, thank you for bringing us here together virtually to stand in solidarity with our brothers and sisters and press forward in the fight for justice. We thank you for bringing us this far in our campaign and pray that you continue to be with us as we travel down the path of implementation. We ask that you soften the hearts of all elected officials and help them to do what is right and just. Soften the hearts of all property owners and help them to remember that everyone deserves a home. We ask all these things, and Lord, hear our prayer. Amen.
We are doing this teach-in on behalf of the Just Housing Initiative Coalition, which is comprised of over 100 organizations, including Community Renewal Society, centered on people, families, and communities impacted by mass incarceration and racial segregation in the fight for fair housing. The coalition embarked on this campaign to increase housing fairness for people and families impacted by the incarceration system, because we realize that not only is fair access to housing a right that all people should have, but that sustainable housing was one of the key components necessary to reduce recidivism. One of the advocates for the Just Housing Amendment had this powerful quote to share. "There's more of an urgency when it's actually your situation. when you're the one or your family member is actually the one who's being discriminated against. One of the major barriers to stable housing had been a person's arrest and conviction records. As you can see here, 79% of participants who were surveyed in a study by the Ella Baker Center were either not able to get housing because of their own or a loved one's conviction history. More than half were forced to live with family members because of a lack of housing options. Families feel a tremendous amount of stress and pressure in housing a loved one with a record, as well because of the likelihood that they themselves will get evicted. Arrest and conviction records block fair access to housing across the country. 1 in 3 Americans has an arrest and conviction record. Could be an arrest, conviction, warrant, etc. 1 in 9 Black children has a parent in prison. 1 in 14 children overall. The use of using arrest and conviction histories restricts housing options and mobility, imparts a major cost on society, and perpetuates discrimination. In 2016, the federal government officially recognized the racially discriminatory impact of arrest and conviction records on housing access for Black and Brown Americans. In fact, fair housing testing in New Orleans and Washington, D.C. showed that arrest and conviction record screening policies are often used as a tool for discrimination. Studies have also shown that African Americans who are looking for housing will often be told that if they have a felony on their record, they will be flat out denied, whereas whites were shown more likely to be given a chance to work something out with a potential housing provider. In looking specifically at our area, on average, more than 10,600 people return to zip codes within Cook County each year. 78% of the women who return to Cook County reported having children. Housing discrimination does not just affect individuals, but entire families and communities. The Just Housing Amendment was drafted in response to this gross injustice. Here are some thoughts from both returning citizens and landlords on the amendment. Wanda said, "I feel like if I have paid my debt to society, why do you keep holding it over my head? I'm back in the system. I can vote, I can work, I can do all those things, but find a place to live." Anne, a landlord and CRS supporter, stated, "Keeping people with criminal records out doesn't keep our communities safe. As landlords, we can help these returning citizens come back to society." Ron, a returned citizen, wrote, "I always prefer if I can talk to a person, because if it's a person, you can sit down and appeal to them." The Fair Housing Act prohibits discrimination because of race, color, national origin, religion, sex, familial status, and disability. Expungement and sealing removes records from public view. Expungement erases the record, while sealing a record hides the record from most of the public's view. The Fair Credit Reporting Act is a federal law that helps to ensure the accuracy, fairness, and privacy of information in Consumer Credit Bureau files. Additionally, CRS, as a part of the Rocky Coalition, took part in passing the Housing as a Human Right Act in the state of Illinois that creates a civil rights violation under the Illinois Human Rights Act to those who refuse to sell, rent, or otherwise make housing unavailable to any buyer or renter based on an arrest not leading to a finding of guilt, a juvenile record, or a criminal history record ordered expunged, sealed, or impounded. As you can see, the Just Housing Amendment is part of a broader set of protection laws that all work together to ensure fairness and equity in the treatment of housing applicants.
So now you have a bit of a background on the importance of housing stability for justice involved individuals, let's take a bit of a closer look at the Just Housing Amendment and what it does and how it works. At its core, the Just Housing Amendment require landlords to do an individualized assessment to determine if an individual would be a good tenant based on who they are today rather than what they've done in the past. The slide that you see on your screen now, we see a Craigslist ad. And in large capital letters, it says that anyone who has a felony will not be considered. And this Just Housing Amendment is designed to stop such discriminatory practices. The Just Housing Amendment prohibits housing discrimination based on what is called covered criminal history. And this means that one cannot deny housing due to, first of all, arrests, charges, or citations that don't result in a conviction, or juvenile records, or records that have been sealed or expunged, or cases where there was a diversion or some kind of deferral of judgment. And very important, cannot consider any convictions over more than 3 years in the past, with some exceptions, which we'll discuss in just a moment. There are some instances where a housing provider can use convictions older than 3 years as the basis for denial. And the first instance is when there is either a federal or state law that mandates such a denial. For example, where a housing provider is a public housing authority, that there's often state and federal guidelines that basically say that you cannot rent to an individual if they are currently using illegal drugs, or if they have manufactured methamphetamines in a federally subsidized rental in the past, or if they're on a registry of sex offenders. Additionally, even in public housing, private housing rather, a person can be denied housing if they're currently required to register based on past sex offenses, or if they are subject to a residency restriction because of such past offenses. Finally, any housing applicant who is otherwise qualified and has a conviction within the last 3 years may have to undergo an individualized assessment, which is basically to determine if the person has a demonstrable risk to either personal safety or property. And if a housing provider decides that an individual does present such a risk, then they must inform the applicant about their finding, and there's guidance in the Just Housing Amendment on how to do that. So let's now turn to the application process under the amendment. In this slide, you can see the steps broken down. First, a housing provider determines whether the applicant is qualified by conducting what is called an initial screening. And this can include things like checking on credit scores, verifying income, checking references, checking past rental history, etc. So if and when the applicant has passed this initial screening stage, then the housing provider can secure and review a criminal background check. And in doing so, they have to limit their screening to convictions within the last 3 years. Now, if the housing provider, after receiving and reviewing that criminal background checks, finds that there's something that could potentially justify a denial of housing to the applicant, then they need to provide a copy of that criminal background to the applicant within 5 days. Then the applicant has 5 days to provide information, documentation, whatever, to refute or basically, show that it's that evidence, that documentation that should not be considered by itself. And this can include evidence of rehabilitation. The provider then takes the information that's been provided and does an individualized assessment and comes to a decision as to whether the person can be admitted to the housing or denied. And the next few slides will go into greater detail on each of the steps. So in the pre-qualification stage, the housing provider must evaluate all the eligibility criteria other than conviction history. Until that evaluation is complete, the housing provider cannot consider conviction history. In practical terms, this means that housing applications should not have any questions about criminal history on them. And then the housing provider must give notice when the individual has passed the initial pre-screening step and that they are going on to get the criminal background check. And okay. After the pre-qualification stage, the housing provider may run a criminal background check, but again, as we said before, they can only consider those convictions within the past 3 years, with a few exceptions.
The next step is that within 5 days, the housing provider must provide a copy of the criminal background check and selection criteria to the applicant. There are 3 ways this can be done. 1 is in person, 2 by certified mail, and 3 by electronic communication like email. Within 5 days of receiving the criminal background check and selection criteria, the applicant can then may then produce evidence to dispute the accuracy and relevance of the conviction history. Criminal records have been notoriously inaccurate over the course of time. Some inaccuracies include same name but different person, missing case outcomes, and misclassifications of felonies versus misdemeanors. Applicants may dispute inaccuracies by submitting correct documentation, such as copies of correct criminal records obtained directly from the appropriate court or correct identification with matching social security number. Disputing relevance may be primarily completed through submitting evidence of rehabilitation. Some examples of rehabilitation are court-issued certificates of compliance, employer recommendations, educational attainment or vocational professional training, completion or active participation in rehabilitative treatment, and various letters of recommendation from various organizations or people, such as community organizations, counselors, parole or probation officers, community leaders, religious institutions or leaders, etc. Once the housing provider receives this information, the provider will conduct an individualized assessment on the applicant and make a decision of whether to admit or deny housing. This assessment looks at all factors related to the conviction history, but again, not within only within the last 3 years, and then considers whether those factors negatively impact the person's ability to fulfill the responsibilities of tenancy. These factors include the nature and severity and recency of the underlying conduct, the nature of sentencing, the number of convictions, the length of time since the last conviction and the age of the person at the time of conviction, evidence of rehabilitation, the tenant history before and after conviction, whether the conviction was related to the applicant's disability, if one exists, and if the applicant is a person with a disability, whether any reasonable accommodation could be provided to lessen any demonstrable risk. If the housing provider chooses to deny housing after all this, they must provide a written notice of denial and explain why denial is necessary to protect against demonstrable risk of persons or property. The provider must also inform the applicant of their right to file a complaint with the Cook County Commission on Human Rights.
Okay, so Municipality Opt Out. It's very important for all of our citizens and all of our leaders to know their rights and landlords to know how to not break new law, but very important for our leaders and municipalities to understand why this is important and to choose not to opt out. Some townships within Cook County have the ability to opt out of the amendment because of the home rule status. So what is home rule? The Illinois Constitution mandates that any municipality that has a population of more than 25,000 residents are considered home rule units, and the local governing body may execute any power pertaining to its government, including the power to regulate for the protection of the public health, safety, morals, and welfare. For the city of Chicago, the governing body would be the mayor and the city council. For the suburban municipalities that qualify, the governing body would be the mayor and village trustees. If a home rule municipality has a local ordinance that conflicts with a county ordinance, the municipal ordinance shall prevail and within its jurisdiction. So how does this affect the just housing ordinance? There are 88 municipalities in Cook County that have home rule status. Because of this ruling, these 88 municipalities could choose to opt out of the amendment if they believe it is a conflict. So our faith would say that this is not in conflict. Scripture says, let all bitterness and wrath and anger and clamor and slander be put away from you, along with all malice. Be kind to one another, tenderhearted, forgiving one another, as God in Christ forgave you. We are called to love our neighbor. We must love our fellow man as our neighbor. Effective love of our neighbor involves concern for their living conditions, and this amendment is a step towards providing stable housing for people who do not have access to it. It is important that we move forward with expressing the good that this ordinance creates for our brothers and sisters and speak with our elected officials to educate them on this ordinance, how it works, to improve our area, and how this is a good thing, that they should not opt out of participating. With us now equipped with this knowledge, let us move forward to put our faith in action. I will turn it over.
Now, I want to open up the discussion for questions. And looking at our chat box here, I see no questions. That tells us we did a great job in explaining and going through this process. If you do have a question, I would encourage you to type it into your chat box now. And after the next screen, we'll come back to it. How you can get involved. Before we leave for the evening, we want to take a moment to discuss how you can continue to be involved in the fight for justice and advance the Just Housing Amendment. As we stated earlier, there are 88 municipalities within Cook County that have home rule status. Each of you will receive a resource package at the completion of this training that you may reference to find out if you live in a home rule municipality. If you do, there are several ways in which you can get involved. One, you can schedule an in-district or virtual meeting with your local elected official in order to discuss the Just Housing Amendment and why you feel that this is an important legislation for your area. Two, you may schedule a teach-in, such as this one, or a panel discussion to educate your local community about the Just Housing Amendment. And three, you may spread the word about the importance of this legislation so that we may continue to change our world and the outlook in which people have on our returned brothers and sisters. Remember that everyone deserves a place to call home. And I do see we have some questions from Karen, and forgive me, Karen Alanis. If you live in a suburb with home rule, what is the best argument to bring to our village trustees?
So Karen, this is Sarah with CRS, and anyone from any one of the presenters are welcome to jump in. But what I would say to that is that really having stable housing helps people get back on their feet and make sure that they don't get back into the system. And it's really beneficial to everyone if people have access to stable housing. So this law, it doesn't just impact a certain group, it really affects everyone, everyone in your township.
I would add, this is Alan, I would add to that I think you can make an argument that we want a society that's fair and just. And to do that, you've got to basically, people who are seeking housing have to be evaluated in a reasonable way. And this Just Housing Amendment sets up a structure for that. And, rather than having some kind of, blanket discrimination or blanket thing, it sets up that in situations where there's been recent evictions and so forth, there's an individualized assessment. People are able to present evidence. So we're looking at the individual and judging them, and it's a fair system. And, that's the kind of society we want to work in, live in. And so that's what kind of argument I would try to make.
So the data show that the Just Housing Amendment or having stable housing prevents recidivism. Can we say that?
Yeah.
Okay, cool. Thank you.
Yeah, jobs and housing are probably been found to be the two most important things for, preventing recidivism. Yeah.
Okay, thank you.
Definitely, Karen, it prevents individuals from couch surfing, becoming frustrated and reverting back to the life that got them incarcerated in the first place. As Alan said, housing and a job are the two most important things to help alleviate or reduce recidivism.
Okay, thank you.
It may be beneficial to add that we didn't really address in this teach-in that not every individual that has an arrest record is returning from prison. Although that's a huge issue that we wanted to focus on, many individuals have an arrest record within the last 3 years that are now blocked from housing. So that's also a huge portion of population, especially in the suburbs when you're addressing your township.
Okay, from Reverend Jackie, what is the status of this provision in Cook County now?
Well, I can try to work. It was officially effective at the beginning of this year. The Cook County Commission on Human Rights basically has been creating things to help educate both the housing providers and materials for returning citizens and communities and so forth, so they can be educated. Basically, and at this point, there's kind of if you want to call it a leniency toward education. The idea is as compared to finding everybody. So but the rollout, the law is in effect, but not everybody is automatically going to be aware of it or follow it. So we do have a responsibility, each of us as citizens, to encourage any individual who experiences discrimination that should not have occurred under the Just Housing Amendment to bring their complaint to the Cook County Human Rights Ordinance. I've done that twice myself, as I've been working with the returning citizens who's been seeking, in this case, affordable senior housing and so forth. But you run into these applications that still ask about criminal history right off the bat. And so
Yeah.
bringing complaints of whatever nature they are to the Commission on Human Rights can then get them to be in communication with organizations, landlords, et cetera, to change their applications, et cetera, and come into compliance. So it's really, at this point, I think, a process of getting everybody up, in line, if you want to call it that, and become educated and compliant.
That is correct. Just to piggyback on what Alan has said, it is an ordinance, an amendment, and so the legislative for getting it passed is a portion of this action is done, and what we're involved in now and why we're having this teach-in, and other municipalities have had panel discussions at their various churches, is that we are in the educational phase, and education for not only the elected officials, but education for those who are affected by this amendment, and for those that that are looking to assist our returning citizens in their quest for finding stability. Our next question is from Marcia, and she asked, will slides be made available to us, to those participating?
I was just answering that one in the chat box. After the training, we'll provide a packet for everyone who is here that will include the presentation slides as well as additional materials, including brochures and frequently asked questions from the Cook County Commissioner's Office.
Great.
All righty, and I'll try to keep up with you, Rashana, in terms of those that you're asking. Reverend Jackie asked what groups have offered the strongest opposition to this. I would imagine Realtors Association has been the largest opponent to this amendment.
Yeah, and landlord associations as well. We had opposition, but then now everyone is working together to make sure that everyone's informed, landlords, tenants, of the law so that they can follow. But initially, back when we were trying to pass it, that was a huge, the landlords associations were a big, were very opposed to passing this.
All right, great.
The reason that we are doing these educational teach-ins is because as we progressed along in the campaign, we were beginning to notice that the realtors and the realtor associations were starting to shift in terms of their focus and in terms of their tactics. And so we felt as though part of that would be to go directly to those different elected officials who do have the ability to opt out and therefore not participate in this, and therefore they would get their win, sort of like, losing the battle but winning the war. And so that's why we're doing teach-ins like this, so that we can not only educate our base, but educate our constituents and try to educate our elected officials in a way so that they understand why this is important. So if anyone tries to convince them to opt out, they will be equipped with knowledge to continue to work towards this.
Looks like we have a couple of raised hands, where I see one in Marcia Borders.
I can't remember now. It was in response to some question that somebody had asked. Oh, I know, about the application process. It would seem that at least the first step in the application, when they're not asking initially about criminal history on the application, once that's straightened out, that you would be dealing, first of all, with a qualified applicant. I mean, before even considering what their criminal history is or anything like that. And I think that's like a really important thing to point out, because if we have applications set up like that, then people can't just be thrown out of the process right away just because someone suspects that they have a criminal history. So I think, making that making the change in the application would really be very important. And I don't know how we would go about doing that and whose responsibility that is. Is it on the landlords or whom?
Well, the landlords, whoever the housing provider is, should be doing it based on communication they've gotten. But if they haven't done it, then it's incumbent upon whoever is aware of the problem to bring it to the attention of the Cook County Commission on Human Rights. I mean, it could be a housing applicant, or it could be organizations that are concerned about what's in an application. And, basically they could first approach the organization if they wanted to and say, hey, you should really, are you aware of this? But, but there is a process, and there's a form for submitting to the Cook County Commission on Human Rights to say, hey, this is, you got this problem out there and they're not abiding by the law. You need to be in touch with them to get them to correct their, application or other processes.
I put in the chat also that if we're approaching our mayors and trustees and all the home rule areas, we should automatically provide this information to them just to say, are you aware of this? Because again, they're in contact with a lot of people within the village or wherever you live. And so that's still another way of educating people. First, right off the bat, as you introduce yourself in this position that, we're trying to make sure that they're on board with.
Yeah, there's different ways. You could be providing them quite a bit of information right away and ask how familiar they are, but also by having some kind of virtual town hall with elected officials there and others from the community, kind of a teach-in, but discussion also, and is also helpful.
Absolutely, and this is one of the reasons we're having this training, so to help us all determine who we need to be looking at, who we need to be talking to, who we need to make sure is aware of this this important amendment. This is the last question. Well, actually, it's going to be two questions because it's from the same person. Linda asked which communities have opted in, and then she asked, have you heard of success stories because of the amendment? And these are going to be the last questions we're going to entertain this evening.
So for the opt-in question, it works oppositely. As of right now, all communities are automatically opted in because the amendment has been passed by the by Cook County Commissioners. So it is law. The townships and the city have the opportunity to opt out should they wish to, but I don't believe any have opted out as of this point. So.
Yeah, and we're confident that Chicago will not be opting out, but we have concerns about some of the suburban townships, cities, municipalities.
And we do encourage all of you, if you are interested in meeting with your trustees, with aldermen, to educate them as well. I know everything's virtually, but we can offer support to help you educate them. And this was the purpose of this training as well, so that they don't try and pursue opting out.
In terms of success stories, I do have one. Robert, who's at University UCC in Hyde Park, lives in Berwyn, which is one of our Cook County townships. After I did a one-on-one with him, he got super excited about it and was already in touch with his township trustees and was able to get it on the agenda for their meeting, talk to the trustees, and got them to decide not to opt out. So that's not a personally affected person by the amendment, but he did have success and got excited about the info. So Berwyn will remain opted in.
Okay.
And
I do.
I was just going to say, Yvette, as to your question about a time limit, no, there, to my knowledge, there is no time limit for opting out.
Okay, and we are here to help.
Before we go there, Will, I'm sorry, Reverend Jackie had one more question.
Oh, did she?
If I could just speak it, because it's a stupid question, please forgive me. I'm just trying to get a handle on if it is the law, and I'm in Cook County and I'm in Chicago. If it's the law, what am I doing? What is, if it is currently the law, what is it that I am doing? That may sound dumb, but that's the question.
So there's kind of two facets to what we're doing right now. I know we've been focused at the end of this primarily on the opting out thing and informing who would be your alderman, that make sure that he or she supports it and continues to inform their population in that ward. But I think most importantly is informing potentially affected residents, informing realtors and landlord associations exactly how to implement it to make sure that it's being done correctly so as not to discriminate against affected populations. So it's right now that's the most important thing that we're trying to overcome, is to get the information to affected individuals so that they know what their protections are, because this is brand new. And one of those easy steps is talking to the alderman, because as someone had said previously, the aldermen have a very close relationship, hopefully, with their constituents. They're a great source of information in their ward. So that's a really easy way to get this information in the hands of the people that need it.
Or if you want the easiest way to help, you can go on Craigslist and look at housing posts. And if you see like what we had that was a real post from February or January, just flag it. Say this is illegal now, no blanket bans, flag it. Super easy while watching Netflix.
Thank you.
We are here to help. Reverend Jackie and others, you are not alone, and we're here to help. Should you have any questions in the future, please feel free to reach out to any of the people on the screen representing the Just Housing Coalition. And we thank you all for joining us today.
Thanks, everybody.
Thank you.
Thank you.